Good morning, and thank you for joining Main Street's livecast this morning. Unfortunately, Ron is not available to join us today, so I am going to be doing the livecast on assignment of rents. One of the reasons why we are doing this livecast, it won't be very long today, but I have gotten a couple emails from investors in reference to assignment of rents. And what can they do and what can't they do in reference to doing assignment of rents. But before I do that, I do need to do our housekeeping our housekeeping of that. Main Street Capital Partners is not giving you any type of legal advice whatsoever, and we are not giving you any investment advice. If you have any questions, you should seek legal counsel, or you should actually talk to your attorney or accountant. I'm sorry. But one of the funny questions is that I got on an assignment of rent clause that someone found on their note was, could they just send the borrower a letter and start telling them to send the rents, not the renter, not the borrower, but the tenant, if they could just send them a letter and ask them to start paying the rent to them as the investor of the note. You cannot do that. There is a process that you have to go through. And one of the things that you have to do is you actually have to put a receivership in place. And in order to put that receivership in place, you actually have to go through a court process. And sometimes that court process can be very expensive, but could be very profitable depending on how long you're collecting the rents into the receivership and the location of the property. New Jersey, for instance, or New York, the foreclosure process is very long and rents are very, very high in those areas. So if you have a person collecting $2,000 to $3,000 a month for rent on a property that you actually hold a note on, you can actually go through a two-step process. You can continue with your foreclosure process, but you can also have a receivership put in place to be able to collect the rents. So what happens is that there is a court hearing. In that court hearing, the judge or the magistrate will appoint a receiver, which normally is a property management company, and they are going to actually take care of the property, and they're going to actually collect the rents, and all of the monies will be held in a bank account. If there's any repairs that need to be done, if any maintenance needs to be done on the property, such as cutting the grass, marketing if the property becomes vacant, all of those monies actually that are collected, the expenses will come out. And depending on the receivership, I think that they generally get anywhere from 7 to 10% for overseeing the property. You cannot select the property management company that is going to take care of the receivership. That is court appointed. I did some digging on one of the ones that I took care of a few years ago, and I wanted to know, how did this property management get selected? Because I went to New Jersey and I actually met with that property management company, and through the conversation I found out that they were friends with the judge. It's not what you know, it's who you know. But this particular receivership or account actually had probably about $90,000 that they had collected in rents. And we were still going through the foreclosure process. So once we completed the foreclosure process, or once you complete the foreclosure process and you have a deficiency balance, you still have to petition the court to actually be able to get that money. It doesn't automatically become yours. Eventually it will be released to you, but until the complete foreclosure process is done, you can't touch any of that money other than to take care of the property. The other question that I had that was kind of off the wall was, this was a New Jersey guy, and he says, well, Saprina, can I just show up at the house and tell them that they have to pay me rent? No, you cannot. No, you should not. We want to always make sure that we are being compliant and we are abiding by the laws and the rules and regulations that we're governed by. And you cannot make a tenant pay you rent, whether you're the note holder or not, without going through the court process. It can be very profitable, but I want you to also understand when I started out saying that it can be very expensive. Depending on the state, I think Chrissy was working on one, I think it was in Texas, and it was going to be a few $1,000s in order to be able to do that. So you also have to look at the timeline on how long it's going to take you in order to put that receivership in place. In Texas, sometimes it may not make sense for you to put a receivership in place because the foreclosure process is such a short period, unless there's some legalities or some litigations that's holding you up that you can't foreclose. But generally, if you have issues with processing your foreclosure, you're probably going to have the same issues on enforcing your assignment of rent clause. So some other things that you need to make sure that are in place when you're trying to enforce an assignment of rent clause. Make sure that there's no break in your assignment chains. Make sure that your assignment is recorded. If your assignments are not recorded, again, you can't really enforce something in the courts if you haven't done what you're supposed to in reference to your paperwork. So I would also make sure that if this is something that you find in your note that there is an assignment of rent clause, make sure that you've checked with your custodian. Your custodian is the person who is actually handling your collateral files or your collateral documents, to making sure that there's no breaks in the assignment chain and you're not going to have any issues once you send that file to an attorney to enforce the assignment of rent clause. The other thing is that when you decide to put a receivership in place, it's good to know the condition of the interior part of the property, because if you're going to have to spend more money than you're going to make to rent this property out, if it's vacant or if it becomes vacant, that's something that you also should factor in. So you go through all of this process, you actually get the receivership put in place, and the tenant moves out, and then you get inside and you see that it's just a disaster, and it's going to cost you $7,000 to $10,000 even before you get it, to the place where you can rent it out again. So this is a good clause to try to enforce if it makes sense, but don't do it just for the habit of doing it. The other thing in reference to enforcing an assignment of rents is make sure that if you're in second position, because when you're looking at your documents, you can find that there's a rider on a first or a second on the assignment of rent clause. Make sure that the first mortgage company hasn't already started that process for putting a receivership in place or enforcing the assignment of rent clause if you're in second position. It's sometimes very hard to tell if that's happened or not, but even if you pick up the phone and you call the first lender and ask them if they have an assignment of rent clause, or if it's some way for you to find that information out, it just makes sense to verify that part of it before you spend a couple $1,000s in second position. I know a lot of you that are on the call are second lien holders, not first, and you will see that rider on first or second mortgages, but make sure you're not throwing good money away for nothing. And those are just a few things to think about when you're going through the assignment of rent clause. I did say that this broadcast was going to be very short today, but I don't see any questions coming in reference to the assignment of rent clause. I really don't have anything else to talk about in reference to the assignment of rent clause. It's a very, very short topic. It can be very, very profitable. One of the thinking outside the box ways to make money or to recover some of your losses during the note process with your investment. But I want you to make sure that you're compliant, you follow the law, you aren't doing things that you should not be doing, and make sure that you find an attorney that actually can do this for you. And there's no way, as a note investor, that you can enforce an assignment of rent clause on your own. I also want to just take the time to thank you for following us on our live cast with, we have more information coming. I don't know what the topic's going to be next week, but every single week on Tuesday, we will have a live cast giving you some new information or just bringing you up to speed on what's going on in the note space. I want to thank you very much for your time, and you guys have a wonderful day and take care.